According on record for the 8/15 calendar, we have one item to deal with this time. That would be a citation issued to Janaya Lopez, ticket number 5A0068074. Responding to the officer's note, that ticket is hereby dismissed. And with that, we can go off record until darn, yeah, that's there isn't anything in the queue about Mr. Estrada, so if they have a dispo, they'll have to figure that out. Well, we'll see if we can get full compliance. There's something on, is this something you've seen? new senior apartments in Yelm are stunning. Take a look.
No.
Should we see what that's all about?
Oh, it's just taking you to a search, I guess, search engine too.
Oh,
You're not looking for anything like that.
no, all I was doing, search results. Oh, that's just a trickery thing. Oh, no. No, I'm definitely not looking. I saw Yelm, but I'm not looking for the house. The real estate market. You have a dispo, we're gonna need, probably we don't have any paperwork on that, but if you're gonna do a dispo, we need some. Mr. Estrada, come on up and have a seat. Mr. Estrada, come on up and have a seat if you would. We'll take your matter now. You're representing yourself.
Yes.
And that's by choice. You do have a right to talk to a lawyer if you want to.
No, I'm here for,
If you're comfortable
represent
resolving the
myself.
matter yourself,
counsel.
we'll take the matter. I just wanted to let you know that.
okay, all right, thank you.
Matter set for a pretrial at this time. I'll turn to the city for the status of the matter.
Your Honor, Mr. Sean spoke, come to a resolution. We'll be entering into SOC, no criminal law.
Mr. Estrada, do you disagree with all with anything Mr.
I agree with everything.
Mr. Ratfield just said?
Yeah.
An SOC is a contract between yourself and the city, under the terms of which this charge will be dismissed if you do what you're agreeing to do, and that's a $250 cost. The most important thing is don't violate the law and don't go to places where you've been from where you've been trespassed. Now, in return for the agreement, you've given up your right to go to trial, have witnesses, appeal if you lose a trial. If there's a violation of the agreement and the city proves that, we'll have a hearing based on the police reports, and that would almost certainly result in a conviction for an offense which bears up to, this being second degree, up to 90 days in jail and up to $1,000 fine. We don't want to go there.
No, sir.
Now, the costs will be payable within the 6 months. We can put you on a payment program if you want, or just leave it up to you to get that paid within the
Yes, sir.
within the 6 months.
I'm just gonna pay the whole amount.
Okay, great. I'll approve the agreement. Now, we want to send you a copy of that agreement, so you can look that over and give us a call, or give Mr. Gratfield a call if you have any questions.
Okay.
There's a form there on the before you. It says contact information sheet. What I want you to do is fill that out and bring it up here. We're very shorthanded today. And so ordinarily you'd be able to get a copy of that before you left here, but today we can't do that.
Okay. All right.
There's the city's having an event where minimal staffing.
Okay.
But go ahead and fill that out, leave it here. You'll be free to leave at this time, and we will be mailing you to your address a
Okay.
copy of today's agreement.
Okay, Your Honor.
You've got an agreement here to get the charge dismissed. Hopefully, 6 months from now, we can simply review the file, dismiss the charge, and without you needing to come back to court. I'm going to wish you the best of luck. Thank you for appearing, and you take care. Stay warm out there, and
Yeah, thank you.
have a good day.
Good way. Thank you.
We have somebody here for the 9 o'clock here. We're a little bit early on that, and I think you have an attorney. We'll address your matter once the attorney appears. Sir, are you here for court? Mr. Smith, come on up and have a seat. You're here for a review. How are you? And for the record, you're John Thomas Smith. Right. We do have this eval from Northwest Resources. Now they recommend that you complete what's called moral recognition therapy. Have you attend that once a week for 1.5 hour sessions? Now, are you going to do that or get a? Have you? Pardon?
Think I start.
You do start next month? Yeah, oh, wonderful. I'm a great believer in better late than never. What we'll do is simply strike the hearing as long as you're starting it. Do you have a start date on it? You've done the victim impact panel. That's a great start here. What I think we better do, Mr. Smith, is let's reset the matter. You're going to start next month. That's March. Why don't we reset a hearing for the first court date in April? Now, if we have something on file that you have started the moral recognition therapy, you don't need to appear in court. But if you haven't, you're going to need to show up and readdress the. I'll sign an order resetting the matter to April 10th, 2025. Now, I want you to fill out. We're going to have to mail you a copy of today's order, so I want you to fill out this form that's on the counter there in front of you. We need your name and a good mailing address and a contact number or email address if you have that. Smith, thank you for appearing. I hope everything's going well with you. I want to thank you for being here. You take care of yourself and hopefully, that you're gonna get through the rest of the obligations you have here. You take care, have a good day and stay warm out there. What we're gonna have to do is, since we're so shorthanded, yes, we can certainly give you a copy of that. I was hoping we'd had two of them, but we don't. What we'll have to do, we'll mail you a copy of the evaluation. And again, you're always entitled to, if you disagree with the eval, you're always entitled to get another one. But
Thank you.
but that's your choice. Mr. Smith, thank you. Yeah, I need it. Oh. Go ahead, Desiree Edwards. Ms. Edwards, come on up and have a seat. It looks like, we have some fees going to collection where there's a outstanding balance. What do we want to do? For the record, you're Desiree Marie Edwards. Good morning to you. Thank you for appearing. We can just simply send that to collections. What? Pardon? Well, how much? If all you can afford is $10, what I'd rather have you do is spend your money on the other obligation you have here, and that's to do alcohol and drug information school. You paid for that? The 27th of this month? Oh, great. That was now that I think is much more important. When would be the next time after April 27th you'd be able to make a payment? Oh, you do. I'm glad to hear that. That's great. Ms. Edwards, it's a great step in the right direction. Why don't we reset the matter to, let's go out a little bit, April 10th, and we'll take another look at the financial aspect, and hopefully by then you'll have proof on file that you've done the alcohol and drug information school. That's more important, I think, than the money. So I want you to make sure you are attending that. Any questions at all? But you're working now. That's great. That I am very glad to hear. Are you enjoying what you're doing? That's the start is it's really good to be working. And now that you are working, that may qualify you for something you like to do better than that. I'm going to wish you the best of luck. I'm going to sign the order resetting the matter to April 10th. Now, what I want you to do is fill out that form that's on the desk. We need your name because today we're going to have to mail you a copy of the order. We want to make absolutely sure that we have a valid address. And when you've completed that, Ms. Edwards, if you'd leave that in the basket here, that'd be great. Ms. Mr. Hatfield, the jail is now on. We'll, I think, address that matter. Ms. Edwards, thank you very much. Good luck to you, and thank you for appearing.
Good morning, Your Honor.
Good morning, Mr. Haverco. We can take your matter now if you wish.
Yeah. Yeah, we're ready. Yeah, we're ready, Your Honor. We'd like to go ahead and just proceed with a formal arraignment on both matters, and then we'd like to address release conditions.
Of course. Good morning, sir. Is your full name Joshua Aaron Novello?
Yes, Your Honor.
Mr. Novello, the citations I have allege that on or about February 4th, 2025, you committed the offenses of assault in the 4th degree, domestic violence, and the second offense would be obstructing a law enforcement officer in the performance of his duty. You have a second charge of violating the terms of a protection order on or about February 7th, 2025. All three charges are gross misdemeanors. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine for each charge. I'm going to appoint Mr. Haverco to represent you at this time, and he's going to enter a plea on your behalf.
Thank you, Your Honor. Would stipulate to probable cause on all matters and ask the court to enter not guilty, please.
Mr. Novello, a plea of not guilty has been entered on your behalf as to each and every charge. We're going to set the matter for a pretrial in a moment. In the meantime, I'd like to revisit the terms of release or bail in this matter. Currently, you're being held on $50,000 cash or bond. Mr. Haverco,
Thank you, Your Honor. When I initially reviewed the reports, there was sort of a tenor in the reports of a lot of exigency, and I wasn't really sure, what kind of, I guess, temperament and so on that there would be with Mr. Novello. But I have to say, in meeting with him, he's a very calm person. We can't argue, obviously, the underlying facts of the case, but he seems very calm. He understands the situation. He understands the importance of the order. I asked him, is there somewhere else he could go? He does get some income through military disability. And so he is in a position where he could potentially stay with a friend in Kent. He did mention he could stay in a hotel, but that doesn't strike me as very practical. How long have you known the friend?
Over a year.
Okay.
A year and a half.
You know whether or not he'd let you stay there, or she?
She would. I think so.
Okay. I was just advised of the friend. What's the name? You know who they are?
Sheridan.
Sharon what?
That's
You have a phone number?
my cell phone.
Okay. Well, he understands the importance of staying away from the alleged victim of the case. He understands the importance of abiding by the order. He doesn't have any prior, history, criminal history at all. Like I say, he seems very calm today, very reasonable in his ability to sort of talk about the case a little bit. So I don't know that I don't think there's a general public risk. And I don't think at this point, I don't think there's a big risk to the victim in the case as long as he just stays away from her and abides by the order. So I would ask the court to consider releasing him on his own personal recognizance with a return date on the out of custody calendar, and see if he can arrange, for some other place to stay.
Has this friend that he could stay with been contacted at all? How viable is that, I guess I'm asking?
Do you know the number in your head or is it in your phone?
It's my phone.
So we don't actually have. I don't understand, we're all like that.
Yeah.
Right. So you don't really have her number or?
No, but I'm pretty sure she'll be, she's offered before, I can stay over, you know.
She's a
good
she
friend.
have a girlfriend or? Or-
No, not any sexual relation, just like a friend,
Okay.
actual true friend.
Well, unfortunately, it's one of these things, and this is so common these days, you know, we often have our, you know, contact information for people that we know are close friends and family, you know, we tend to forget about their phone numbers because they're so often in today's modern technology, you know, they're in our phones. He's in, he's in custody, so he doesn't have access to his phone. So it's a little bit of a conundrum and not unusually, he can't recall the phone number off, you know, off memory, but again, I tend to believe him that there is a friend. I don't, my sense is he's not making it up. It's just that it's not unusual for someone to not recall a phone number because we're so reliant on our phones. So I don't know, I guess I'd ask the court to give him a chance. Like I say, he has no criminal history and I think he does understand the importance of not contacting the victim either by phone or any other method, not going to her house. And I think as long as he does that, I think, I don't think there's any other particular safety to the public at large.
Bradfield, city have any position?
City.
Mr. Novello, as it stands right now, the position you're in legally is, in my view, salvageable. And if it remains that way, that's going to be up to you in large part. It concerns me that you violated the order you were served within almost immediately upon release, or within a day or so anyway. It's very, very important that you abide by that. The peace must be kept. You cannot have any contact or go within 1,000 feet of the residence. I'm going to take a chance and release you on your promise to A, stay out of trouble, and B, not drink or consume non-prescribed drugs, and C, do not go within 1,000 feet of that's already in the order that you were served with. Now, violation of a formal no contact order, that's a whole new matter that's very serious, and that escalates with a repeated offense. We'll send down a release order. We're setting a pretrial for February 27, 2025 at 10 a.m. Now, I want you, Mr. Haverco, to write that down for you. Ordinarily, we would send to the jail a release order. And hopefully that is going to be served on you or given you a copy given to you before you leave the jail. But just in case, I want you to take from Mr. Haverco his contact information, a phone number, email address maybe, and contact him immediately upon your release, okay?
Yes, sir.
Mr. Novello, I can't emphasize enough how important it is that you abide by the no contact order. Those things aren't carved in stone. They don't last for forever. And that's something I want you to talk to Mr. Haverco about when you have a chance. But again, please do not violate the no contact order. Any questions?
No, sir. No, Your Honor. Thank you.
Order down to the jail before the morning's over. And you take care, and by all means, appear for court as directed on the 27th of February, and stay in contact with Mr. Haverco. Okay?
Okay, yes, sir.
Thank you, Ron.
Thank you.
Thank you, Mr. Haverco.
So what do you do?
Well, good morning. Do we have you on for a couple of things on the 9 o'clock calendar? I don't know if anybody is here yet. We do have an arraignment, but we'll need Mr. Haverco here for that. And I think we have somebody else as well. Why don't you have a seat? And Mr. Bolt, who is this?
This is, your, Cisneros Chavez. Oh, yeah.
What we'll need to do is have Mr. Haverco here, and he's now en route from the jail. Is we done this? Oh, okay, great.
This is Mr. Acevedo Hernandez.
Yes, I'm here. Can you hear me?
Good morning. We certainly can. Good morning. Mr. Duenholter is now on record. We're ready to proceed with the matter. The interpreter is here. I'll swear him in. You solemnly swear or affirm that you'll accurately translate from Spanish to English and English to Spanish. All of it is spoken in this manner. Okay, thank you. Matter is now set for pretrial. I'm going to turn to your attorney for the status of the matter. But first, I want to affirm that your name is Armando Acevedo Hernandez. Thank you, sir, and good morning.
Good morning, Your Honor. May it please the court, Martin Duenhalter on behalf of Mr. Acevedo Hernandez, who is in court today. Your Honor, I regretfully have to ask for another continuance. We sent the discovery request out and on 1/6/24, and to date, I have not yet had any communications from the prosecutor's office. Maybe the prosecutor could tell me whether they received that or not. I know we emailed it to them. We got their email at Dilly Law.
Bradfield, we're certainly going to reset it. You can't proceed without the discovery.
Not very well.
You're going to get it.
Thank you.
It was mailed on January the 8th.
Oh, emailed. Okay. I wonder. Well, then possibly our problem. I don't know.
Well, we can certainly find out. Why don't we reset the matter to how about the 27th of February? Is that going to work?
Let me get my Google Calendar out. I have to be in an actual court in Pierce County. I have a live pre-trial and then another court commitment as well as a civil trial. Oh boy, that may not be the best date, Your Honor.
How about March 13th?
I have another in-person pretrial in Pierce County that day. Do you do them at 10? Because if I can do the Pierce County at 9.
Well, how about
I don't know if you have a 10 o'clock docket. I'm just asking.
How about March 27th then?
Sold. I am writing it down. March 27, 9 o'clock, Yelm Municipal. Thank you, Your Honor. That will work.
We'll be sending you a copy of the today's order. It'll simply be a notice resetting the matter to the 27th.
Certainly. And then I will try to email the Dilly Law Firm if I'm going to do another look around here. Usually the stuff is in the file appropriately. And if I don't find it by the end of the day, I will email them and ask for another copy of it.
We'll email it to you regardless.
Thank you so much. Thank you so much. And then we can be in touch and maybe possibly we can get this resolved.
Mr. Acevedo, we're resetting the matter to March 27th. The request of yourself and your attorney. We don't have the ability to give you a physical copy of the notice today. We want them to do it. We'll be sending you your attorney notice of the hearing. So I want you to stay in touch with your attorney and be back here on March 27th. Any questions at all? That concludes the matter. Mr. Duenhalter, good to hear from you. Take care. We'll talk to you again on the 27th of March.
Thank you. Always good to see you, Judge Meyer. Take care.
Take care. That concludes the matter. You're free to leave. Any question at all? No. Thank you for appearing. And we'll just have to wait until Mr. Everett goes en route from the, he should be here any minute. We have, oh, okay, yeah. Is Pedro Jose Borges, how do you pronounce your name? We can take that matter now. Good morning, sir. I'm really good at mispronouncing names. I've mispronounced yours, and for that I apologize. Pedro Jose, and your last name is? Bojotes. That's the best I can do. But you've asked for a mitigation hearing on the tickets you got. And I'll be glad to listen to what you have to say about what happened when you got cited. And I'm going to reduce the amount of the ticket. Any question about what we're doing here? Wait. You were cited for speeding and no insurance on January 19th. Tell me what happened here.
So I was speeding because my wife was leaving work and she had called me to come pick her up because her car was broken down. So it's cold that night, was trying to get there, and so I exceeded the speed limit a little bit. So, and that's when the policeman saw me and he pulled me over.
The other ticket was insurance. Do you have insurance?
Yes, I do, and I have it here.
Did he have it when he was cited on January 19th?
Generally, my wife uses her own car and when I had to take the truck and this, I did not take my own car.
In the face of the ticket, the speeding ticket, $217. I'm gonna reduce that to $100.
La multa debe ser $215 y lo voy a reducir a $100. Okay, debe ser, how much is the original fine, Your Honor?
It was originally 217.
Era originalmente 217 y lo puedo reducir a 100.
Reduce that to 100. The no insurance one, that's the bad one, $559. You now have insurance, so I'm gonna reduce that to $100 too. Can you pay that at the rate of $50 a month?
How much would I have to pay in completely, altogether?
200, 100 for each offense.
That's okay.
And the first payment would be due March 13th.
Or I can pay it now.
You can certainly, well, we don't have anybody in the office, so what we do, I'll sign an order allowing $50 a month. Now, we don't have a way of getting you that order today. Now, we can either mail you a copy of the order, or you can stop by and pick it up, say tomorrow. Yeah, I can understand why you were speeding. A spouse that's waiting to be picked up in cold weather is but I wouldn't have wanted you to get in a wreck on the way there and getting there very late.
Yes.
I'm going to wish you the best of luck. Thank you for appearing. And if you have any questions at all, let us know.
So what should I do with this document?
That's just your notice of hearing.
So what should I do from now? As of right now, what should I do?
Right now, doesn't need to do anything. He owes a total of 200. And doesn't have to make a payment until March 13th. And if he wants us to mail him an order, fill out one of those forms there on the desk. Looks like this.
It's okay.
Okay, but we'll have one at the window anytime he wants to stop by. But today, there's nobody in the court offices, so can't give you a copy right now. I want to thank you for appearing. You take care of yourself and drive safely so you get where you're going in a timely fashion. And hopefully your wife's car will not break down again. You take care of yourself. And thank you. Okay. Is Jordi Cisneros Chavez in the courtroom? He's not. Hold on, we'll wait until Mr. Haverco gets here. Do we have another matter we can call?
Do you order the Mancinelli map?
Maybe we can take that now. Good morning. Matter set for a pretrial. Identify yourself by name for the record, please. Okay. I'll turn to your attorney for the status of the matter at this time.
And good morning, Your Honor. Attorney Kate Lansick on behalf of Ms. Mancinelli, who's seated to my left. We've reached a resolution in this matter and would be asking to do a change of plea today.
I am looking at the statement of defendant on plea of guilty in the O court system as we speak.
And Your Honor, I have gone through this document at length with Ms. Mancinelli. She's reviewed it on her own and we've gone through it. I believe that she understands everything that's included in this document. She understands the important constitutional rights she's giving up by entering a plea of guilty. She understands that there's a recommendation in this case and that you, Your Honor, do not have to follow it, and that it is just a recommendation. I do believe she's entering this plea knowingly, freely, and voluntarily.
Is there any recommendation as to fine?
Not to my knowledge.
250.
Good morning, ma'am. Full name, Maggie Elizabeth Mancinelli. I'm looking at a statement of defendant on plea of guilty to one count of negligent driving in the first degree. The city has amended the charge to that much less serious charge. Plea form tells me you're 22 years old, been through the 12th grade. Any problem at all reading, understanding the plea process, going through it with your attorney? Does it disagree at all with anything she said? If I accept the plea, you give up the rights contained in paragraph 5. There's no trial, no appeal, simply a sentencing, which could be up to 90 days in jail and up to a $1,000 fine, regardless of what's recommended by the parties. You realize that. With that in mind, as to a one charge of negligent driving in the first degree alleged to have occurred within the city of Yelm on November 26, 2024, how do you plead guilty or not guilty? Do you make that plea of your own free will? Anybody make any threats or promises to you make it guilty? I do find your statement in paragraph 11 satisfies the factual elements of the plea. I will accept the plea. City, have anything to add with regard to the recommendation? Anything to add with regard to the recommendation?
Just, Your Honor, that this was an agreed and negotiated upon resolution. Ms. Mancinelli has been exceptional throughout this process. She has been proactive. She's completed a chemical dependency evaluation where she was found to have no significant problem. And I believe my paralegal sent that over to the court this morning. She has her alcohol and drug information school scheduled along with her victim impact panel, which will be completed within the next 60 days. So we would just ask the court follow the recommendation. Thank you.
Absolutely. I am going to follow the recommendation. 90 days in jail, all suspended on the condition. You follow the conditions set forth by your attorney. Most important is perhaps not stated, learn from the experience. Your attorney, Mr. Radfield, myself can tell you story after story and, for the rest of the day of just the absolute tragedies that happen out there and the ripple effects on families and friends and significant others that happen. The good thing is, hey, you're here and you didn't hurt anybody and you didn't hurt yourself. That's always a good thing. This will recede in importance as far as your license is concerned and insurance is concerned as time goes by. And again, the most important thing is learn from the experience. No criminal law violations. You've done the drug and alcohol evaluation. Go ahead and attend the necessary ADIS and the alphabet soup. And that will be a learning experience to hear from somebody else about the tragedies that do happen. I'm going to wish you the best of luck. Hopefully this has been just turn out to be a good experience in the long run. Right now it isn't, but hopefully it will be in the future. I'm going to wish you the best of luck and please keep in mind that the most dangerous thing you're ever going to do, more likely than not, is get behind the wheel of a car and get out there in the road, stone cold sober. Good luck to you. we're in a bind today as far as office help is concerned. What I want you to do is fill out the form there, the contact information sheet, so we can mail you a copy of today's paperwork. We will likewise be sending your attorney a copy, but we already have her address.
And Your Honor, just the one thing I would address, in looking at the judgment and sentencing criminal courts, it looks like it is marked for monitored probation, and I would just ask that she be put on bench
The
probation.
bench probation, absolutely. You won't hear from us at all unless there's a problem, and I'm assuming that there's not going to be. All I can do is wish you the best of luck, happy motoring, and today, don't get too cold out there.
Thank you, Your Honor. Have a great day.
Good luck. Thank you, ma'am. Take care. Morning, Ms. Ganem.
Good morning, Your Honor.
And it looks like we may have your client on Zoom as well, or
My client is in the courtroom. The protected party in this pretrial no contact order, I believe, is on Zoom as well.
hey, good morning, Jasmine Mariah McClanahan. Hey, she's present as well. Ms. Ganem, I'll turn to you for the status of the matter. I'm looking at the SOC, but go ahead.
That's correct, Your Honor. Parties have reached a resolution in this matter by way of a stipulated order of continuance that we are proposing to the court. Your Honor, I did have an opportunity to review this document with my client. I've explained to her that this is essentially a contract between herself and the city where she agrees to abide by certain conditions, and in exchange, after a period of 3 months, if she is in compliance, the city has agreed to dismiss this charge or both of these charges. I've gone over the rights that she is waiving by entering into this agreement, as well as the maximum penalties for each charge if she is ever convicted. I've also gone over each of the conditions that she would need to abide by in order to be successful in this agreement. I do feel she is proceeding today, Your Honor, knowingly, intelligently, and voluntarily, and I would ask the court to accept it. Thank you.
Morning, ma'am. For the record, is your full name Jasmine Mariah McLaurin? If I mispronounce your name, I apologize for doing that. Do you disagree at all with anything your attorney just said? You've got a contract with the city at this point, negotiated by your attorney on your behalf. The important thing is learn from the experience. Don't repeat it. The home is where you're supposed to go and everything is supposed to be peaceful. Let's make sure that happens. You've got an agreement under the terms of which this charge can be dismissed. It can go away entirely if you abide by the conditions. The least important one is the $250 cost that was need to be paid within the period of the continuance. Hopefully, we can simply review the matter when the time is up and dismiss the case, and these matters will be at rest. But bear in mind, as your attorney said, in return for the agreement here to get the charges dismissed, you've given up your rights to go to trial. If the city proves that you violated the agreement, we'll have a hearing based on the police reports, and you realize where that would go. That would subject you to the possibility of convictions and jail times for serious offenses. What I'm going to ask you to do is there's a form on the table in front of you. Contact information, see, we're very shorthanded today. We don't have anybody that can make you a copy of the, today's paperwork. We'll be sending your attorney a copy of the paperwork as well. Any questions you have of me?
I just wanted to ask about.
No contact was a condition of release, with the disposition that goes away, unless I'm misunderstanding something.
No, Your Honor, that's our understanding. Mr. McLaurin, the protected party, just wanted to log in and participate in case the court had any questions of him.
Mr. McLaurin is present, but muted. I didn't ask him if he had anything to contribute. Mr. McLaurin, if you want me to know anything, go ahead and speak.
No, not other than the fact that hopefully the contact order can be removed. And yeah, I agree with everything her lawyer said.
All I can do is wish the two of you best of luck, and as we go down the road of life, there are speed bumps here and there, and the job is to negotiate them, keeping the peace, and proceed with life. I'm going to wish you the best of luck. Thank you for appearing. And no, as far as the no contact order, no hostile contact is always a condition of just life in general. Keep it that way. Any question at all, ma'am? Again, good luck to you. Take care. If it resolves the matter, hopefully you won't have to be back to court on this. You take care of yourself, and hopefully if this will turn out to be just another learning experience you can look back on in life and maybe smile. Ms. Ganem, anything further?
Nothing further, Your Honor. Thank you.
That concludes the hearing. We'll be sending you a copy of today's paperwork as well. Take care. That concludes the matter. You're free to leave. If you would, leave that in the basket. We'll be mailing you a copy of the order. Take care. Yes, we can take your matter now. Going to serve the record, your name is Jordy Cisneros Chavez. Let's address your matter now. How are you today?
Good.
Mr. Mold is under oath to translate for us. How are things going? As far as treatment is concerned, what's going on, if any?
So I have done the first ones. I did the victims panel and was pronounced classes. Okay, so I did the evaluation and the first classes of treatment. Said they were going to send me some information for they were going to send me information about the classes, but I haven't received it. Okay, so I thought I was gonna get it by email, but I didn't. I may have been mailed to my house and I haven't received it. Oh, see? Okay, so, excuse me, Your Honor, the interpreter is mistaken. I have received it. This is el horario de las clases. Yes. And that was the schedule for classes, and I have started them.
Okay. We don't have any proof of that yet. Are you able to get us proof that that has happened? Ordinarily, the treatment agency and this Consejo would.
They said that they sent it to the court.
I don't see, excuse me, where we had any. Haven't received any.
No, we haven't. I might have a picture of it.
That'd be great.
this that shows an invitation, a Zoom invitation.
And that took place? No, we're gonna need to have proof on file.
Would you like to see it?
That does,
You say.
I'm a techno dinosaur. I don't understand those. I'm inclined to, I'm not, given the appearance and given that I've been, given those efforts made, I'm inclined to accept his word, but we still need them on file. These agencies are very good at giving treatments, but classes, but they're not very good about following up with a written report.
I think I can ask and get that proof.
What I'm inclined to do at this point is just strike the hearing, so, and we'll monitor that. Hopefully we'll get it within the next week or two. You look well, you look healthy. It looks like everything is going well with you.
Yes.
Life going okay? Good. Glad to hear that. Simply going to strike the hearing. Make sure we get that. We'll monitor that. Make sure we have a current address. What I'm going to ask you to do is fill out one of the forms. Make sure we get mail to you.
So I should do that right now?
Sure. Is Franco Manuel Alvarez in the courtroom? Does not appear. Could we have a couple of people in the courtroom here for a pretrial, waiting to talk to Mr. Haverco? Are you waiting to talk to Mr. Haverco? What's your last name? You're real early. You're scheduled for 1 o'clock. But Mr. Yeah, but hey, hang out. The public defender will be back in a moment. We can take you this morning if you want.
Receive the proof of having attended to the victims panel. It was a that video. That was a video also.
Sarah, I wish you the best. Thank you for appearing. Thank you for your patience. You take care of yourself. Be well. Mr. Mold, I guess we have one more, but we have a non-appearance here, so that would be Franco Manuel Alvarez. Does not answer. If he's not here, it was scheduled for 9 o'clock. If he's not here, I'm going to assume that he's not going to appear. Nope. Hey, take care of yourself. A little chilly out there today. And they're expecting the possibility of snow, at least. Wahoo, yippee. No, not a chance, not a chance. Yeah. So we can take him now. Yeah, let's take him now. Mr. Ratfield, we can take Ilu Savanu now, pro se representing himself. He is present. We'll bring him up now. Drive carefully out there. A lot of idiots on the road, especially when it gets slippery. Good morning, sir.
Yes. Good morning.
I want to
Your Honor.
Ilu Savannah. I'm going to mispronounce your name, and for that I apologize.
Yeah, Sivan, you pronounce it right.
We don't have the best connection. Are you able to hear me okay?
Yes, yes, Your Honor.
Okay, thank you. The matter set for a pretrial at this time. I'll turn to the city for the status of the matter. Mr. Ratfield?
Yes, Your Honor. A few weeks ago,
Good morning, Mr. Savano, did you receive the agreement that was sent to you?
Yes, Your Honor.
Did you go over it?
Yes, Your Honor.
Any questions about it?
Trying to ask you if you dismiss my dismiss my case, please.
That will happen, as the agreement says, 2 years from now. This is an agreement with the city. If you stay out of trouble, pay a probation fee of $250, the charge will be dismissed. It will not go on your record. But in return for this agreement, like the form says, you've given up your right to go to trial, have witnesses, appeal if you lose at trial. If the city proves that you violated the agreement, we'll have a hearing based on the police report, and that would subject you to the likelihood that you'd be found guilty based on the reports of serious criminal charge bearing up to 364 days in jail. Okay?
Okay.
It's a good agreement. Are you going to be able to pay the costs at the rate of $25 a month?
Yes, Your Honor.
Okay. We will again send you a copy of the executed agreement. I presume we have your address. We will email that to you if we can, or I've got Mr. Ratfield. Can you email him a copy of the executed agreement? Mr. Savano, I'm going to wish you the best of luck. Thank you for appearing. You take care of yourself and keep well, okay?
Yes, Your Honor.
That concludes the hearing. And give us a call if you have any questions about the matter, okay? Take
Okay.
care.
I have a question.
Oh, yes, go ahead.
So I have a license right now, so I can't turn it to like Ohio license because my license is from American Samoa. So they locked up there in Seattle. That's why I can't transfer my license into Ohio license.
Now, this charge, won't hurt you from getting relicensed here. This doesn't hurt you at all. You'll still be able to, unless there's something else I don't know about, that you'll be able to relicense where you are. What state are you in now?
Ohio.
You're in Ohio? I don't know what the rules are in Ohio, but yeah, this shouldn't hurt you at all as far as getting relicensed.
Okay.
Does that answer your question?
Yes, sure.
Okay, thank you, Mr. Savano. You take care of yourself.
You as well.
So that takes care of the people that we have on Zoom. Mr. Hatfield, I see in the queue, Edward Barrio, an order of dismissal. Was there going to be an appearance on that? And the agreement is charge is going to be dismissed. I will at this time then sign the order of dismissal. Just filling it out. Is this with or without?
With, or with,
With prejudice?
with prejudice.
I checked that box. I'm checking also order exonerating bail. That having been done, I'll see if they'll now let me sign it. Yep. One charge of criminal trespass. Second degree is dismissed. Next would be Michael Lay. There's a motion to continue Michael Lay. Was there going to be an appearance on that? So, and how far out did you want to go? That's on Lay. I have it up. We can. April 10th it is. Go ahead, no problem. We do have Mr. Carley here for arraignment. He's a little early. He's seated. That's we'll wait. We'll wait. Go ahead and talk to Mr. Dorsey, and we'll. The gears are still grinding. Getting me back to the dashboard. Yeah, that was. System, right, deal with it. Success. Success, yeah, that's, never had that happen before. Going back to the 9 o'clock, there's a motion to continue in the McNinich case. Is gonna there be any?
No.
I'll simply sign the order, resetting the matter to April 10th in that case. That leaves us. Are you a Shidek in the courtroom? Nope. We do have, from the 9 o'clock calendar, we have Mr. Manuel Alvarez. Garrett, going back to page 4, docket number 8. Not appearance on that. It's failure to transfer title within 45 days, which the city sometimes want to amend that to tabs.
Yeah.
That's since he didn't appear, and I don't see any point, no warrant on this case. Docket number 8, page 4. Franco Manuel Alvarez, the charge is amended to expired tabs. And since there was a non-appearance, and we FTA that too. And I think that takes care of the 9s. Going back to the 8:15, no shows. We had a pretty good appearance on that. Order dismissal was signed, docket number 3. We have Jennifer Jenkins. Docket number 2, she's subject to an SOC. She was extended one time, and Jennifer Jenkins in the courtroom. I have no answer.
Your Honor.
Tend to agree with that. Very good. Tammy Balint in the courtroom. We'll take that matter when Mr. Haverco is ready. Go ahead and have a seat. She's on the just warrant quad. Page 6, docket number 1. Here for arraignment, new charge.
Let's see, let's take Tammy Balint.
Ms. Balint, come on up and have a seat. Good morning, ma'am. For the record, your name is Tammy Elizabeth Balint. Warrant was issued for your arrest for failure to appear, but you're here to quash the warrant. We'll have an arraignment at this point. The citation alleges that on or about January 22nd of this year, you committed the offense of loitering in connection with drug-related activity. Gross misdemeanor, the maximum penalty and conviction to be 180 days in jail and or a $1,000 fine. I'm going to appoint Mr. Haverco to represent you in this matter. He'll enter a plea on your behalf at this time.
Stipulated probable cause, Your Honor, ask the court to enter not guilty plea.
This a plea of not guilty preserves your rights pending a pretrial, which we're going to set for a later date. Conditions of release are, they appear for court as directed, of course. Stay in touch with Mr. Haverco. And what I'm going to ask you to do at this point is fill out the form that's at your contact information sheet. We're very shorthanded today.
Put your email address, your phone number, and email address. Okay.
And we're going to have to mail you a copy of today's order, resetting the matter to April 10th.
He has signed everything.
Ms. Balint, thank you for appearing. You take care of yourself. Stay in touch with Mr. Haverco. The document we're going to mail to you will have his contact information on it. But by all means, make sure he has your phone number. The court will have it now. And the form you filled out, we'll need that. Put that here in the basket. And at that point, you'll be free to leave. Take care. Any questions?
I'll just leave it. Yeah. Next, we could call the 945 William Dorsey.
William Dorsey. Mr. Dorsey, good morning. Come on up. For the record, full name, William, middle initial D, Dorsey. Mr. Dorsey, I'll turn to Mr. Haverco for the status of the matter.
Thank you, Your Honor. Entering a straight plea to the charge, we placed a plea statement into O courts.
Mr. Dorsey, I'm looking in O courts at a statement of defendant on plea of guilty. Plea form tells me you're 51 years of age. Any problem at all going over the process of entering a plea of guilty? The plea is to one count of criminal trespass, second degree, which is a simple misdemeanor. The maximum penalty on conviction would be 90 days in jail and or $1,000 fine. I'd be free to impose that regardless of what's recommended. You realize that? If I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing, which could be up to the maximum, and you're giving up the rights contained in paragraph 5 of the form. You agree? You have no rights as far as trial is concerned if I accept the plea. I simply impose a sentence. As to one count of criminal trespass, second degree, alleged to have occurred within the city of Yelm on December 9th, 2024, how do you plead, guilty or not guilty? You make that plea of your own free will. Anybody make any threats or promises to you to make you plead guilty? I will find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements.
Just
Suggested
ask,
sentences.
ask the court to follow the recommendation. It's, all suspended time. Because of his obvious indigent status, city's not asking for a fine, so no financial obligation.
Mr. Dorsey, anything you'd like to tell me? That's, well, hopefully it's been a mistake you've learned from. City, have anything to add? I'll follow the recommendation, 90 days suspended on the condition you have law-abiding behavior, and that includes don't go where you're not welcome, okay? Don't go where you're not welcome to be. Where you've been trespassed from, don't go there. That's one of the conditions. You've got 90 days in jail hanging over your head if you, there's the possibility of that being imposed if you violate that provision. Mr. Dorsey, good luck to you. You take care of yourself. I want you to fill out one of those forms.
Oh, do we, oh, okay.
Yeah, every case we've got to do.
Oh,
that.
every case, okay.
Yeah.
Yeah, okay, gotcha. So, gotcha. All righty. He's filled out the form.
Dorsey, if you'd put the form in the basket here,
Here,
that'll conclude the hearing. You're free to leave. Thank you for appearing. Good luck to you.
Next matter will be Mr. Tillage on the 945.
Good morning, sir. Full name Anthony Tyler Pillage. Matter set for arraignment at this time. Mr. Pillage, a warrant was issued for your arrest because you didn't appear. But you're here now, so we'll arraign you on the charges. And the charges would be knowing possession of a controlled substance, criminal trespass first degree, theft third degree. Those are all gross misdemeanors. The maximum penalty and conviction would be 364 days in jail and or a $5,000 fine. You're also cited for delivery or use of drug paraphernalia and malicious mischief third degree. Those are simple misdemeanors. The maximum penalty and conviction would be 90 days and or $1,000 fine. I'll appoint Mr. Averco, excuse me, to represent you in this matter. He's going to enter a plea on your behalf at this time.
Stipulate the probable cause, Your Honor. Ask the court to enter not guilty, please.
Mr. Pillage, a plea of not guilty to each charge preserves your rights pending a pretrial, which we're going to set. Conditions of release or law-abiding behavior, no drug consumption. Stay in touch with Mr. Haverco and appear for court as directed. Bless you.
They need to know where they.
Village, the contact information for your attorneys on the form. We'll be mailing you a copy of that. Ordinarily, we would give you a copy of that, but today, being shorthanded, we're not able to do that. Any questions at all? Thank you for appearing and take care. We'll see you back here on April 10th. Take care.
Go deliver that up to. Christopher Fair.
Christopher Fair, go ahead and have a seat. Now, we're very shorthanded today, as I indicated. What I want everybody to do is you're going to be handed a contact information sheet. What I want you to do is fill that out. And before you leave, bring it to the basket and leave it with us so we can mail you a copy of your next, of the order of today's order, and it'll have the date of your next hearing, if one on that. Sign right there. Good morning, sir.
He's getting our plea to the charge. There's a plea form in Oak Courts.
For the name, for the
Mr.
record.
Fair.
Christopher
Yeah.
Jane Paul Fair. How do you pronounce your last name? Mr. Fair, I'm looking at a statement of defendant on plea of guilty to one count of reckless burning.
Yep, I've gone over a statement of defendant plea of guilty with Mr. Foray, and the rights he gives up by entering a plea, and I believe he's gonna enter a straight plea to the charge. City's just recommending all suspended jail time. Because of his indigent status, they're not recommending a fine.
Mr. Fair, do you disagree with anything at all Mr. Havercode just said? I'm looking at a statement of defendant on plea of guilty to that charge, reckless burning, second degree. That is a misdemeanor. The maximum penalty on conviction would be 90 days in jail and or $1,000 fine. I would be free to impose that regardless of what's recommended. You realize that. Now, if I accept the plea, excuse me, you give up the rights. Excuse me, a lot of that going around. You give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing. You realize that. You also give up the rights contained in paragraph 5, no trial, no appeal if you lose. With that in mind, as to one count of reckless burning, second degree, alleged to have occurred within the city of Yelm on December 28th, 2024, how do you plead guilty or not guilty? You make that plea of your own free will. Anybody make any threats or promises to you to make you plead guilty? find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the offense. Mr. Fair, I've heard the recommendation, as to sentence. Is there anything you'd like to tell me?
Just sign it right here.
City, have anything to add?
He,
Mr.
you know,
Fair?
he's, unfortunately, you know, homeless and, it was really not up to mischief in any nefarious way. Very cold and had started a fire and, you know, so it was not about trying to, you know, cause problems.
Willfully cause you to
Yeah.
need it. I accept that from
Yeah.
the, Mr. Fair, anything you'd like to tell me? Yeah, that's a, hey, gotta be careful about these things, do what you can to get in and out of the cold. That's, not a good time to be out and about, on the streets, in weather like this. I'm gonna follow the recommendation, 90 days in jail, all suspended on the condition, simply have law-abiding behavior. I'm gonna wish you the best of luck, that's all I can do. Now, did you fill out one of
Yeah,
those
Fill
forms?
this out. Your name, mailing address. If you don't have mailing address, you can try to use, general delivery.
We'd like to mail you a copy of today's paperwork. Hopefully there is a mailing address.
People used to be able to use something called general delivery. I don't know if you still can, but.
I see that now and then. I assume you still can,
Yeah,
but
they hold the mail for like 30 days or something. If you present yourself within that time, they'll give you the mail, I think.
we'll do the best we can, and that's
Right.
about all we can do.
Yeah, just put this here. So take this up to that box.
Spare, I'm gonna wish you the best of luck. You take care of yourself and good luck in getting in and out of the cold, okay? Be well.
Next matter is Jeffrey Pruitt.
Mr. Pruitt, good afternoon. Or good morning, it still is.
We're placing a motion for a continuance in the Oak Courts.
How far did you wanna go?
Four weeks, ordinary course. Just trying to work on, getting an evaluation, process completed here. Oh, we got it already. Oh, cool.
Mr. Pruitt, we're gonna reset the matter. The request of yourself and your attorney, any conditions of release remain in effect. That includes mostly, don't drive unless licensed and insured, and no, general law-abiding behavior. Resetting the matter to March 27th. I'm signing an order to that effect at this time. We'll have to be mailing you a copy of today's order, Mr. Pruitt. Any questions at all? Go ahead and leave your mailing address in the basket here, and we'll see you back here, your next court date. Thank you for appearing and good luck.
Dolly? Placing into Oak Courts a stipulated order of
And
continuance.
this is,
Oh, I'm sorry, Judge. This is Dolly, how do you say it? Rowlett, number 4.
Dolly Jolene. Yeah, Rowlett. Good morning, ma'am. Sorry to interrupt.
So we placed a stipulated order of continuance into Oak Courts, what we call a slow neg. So matter to be continued for 24 months on the usual DUI-related conditions, including the fine that would be imposed on DUI, at the end of which time, if she complies, then the city would move to amend the charge to a negligent driving first degree.
Ms. Rowley, do you disagree with anything Mr. Africo just said?
No,
You've got a contract with the city under the terms of which charge will be reduced to a much, much less serious charge of negligent driving in the first degree. That'll occur 24 months from now. In the meantime, you're agreeing that you're going to stay out of trouble, especially when it comes to drinking and driving. You're also agreeing to pay $990.50 in costs at the rate of $45 a month. And most importantly, stay out of trouble. Get a drug and alcohol evaluation sometime within the next 90 days and make sure we get on file a copy of the evaluation and then compliance with any recommended treatment at all. Those are the conditions. Now, in return for this agreement, you've given up your right to go to trial. If you violate the agreement, city proves that, we'll have a hearing based on the reports, and that would almost certainly result in a catastrophic finding of guilty for a DUI, which is horrible, as you know, from talking to your attorney in terms of your license, your insurance. It's just, you don't want to go there. Purpose of the evaluation is, hey, if there's a problem, let's find out what it is, deal with it, and put it behind us. Hopefully, 24 months from now, we can simply review the matter, close the case, dismissing the charge, or reducing the charge to negligent driving in the first degree, I should say. Any questions at all? We'll be sending you a copy of the, I want you to fill out that form. We'll be sending you a copy of the today's agreement. I want you to read it over carefully, you know, quietly when you've got a little more time than today, and give Mr. Everco a call if you have any questions, okay? But go ahead and leave us your current address and you'll be free to leave. And I wish you the best of luck. You take care of yourself. And you as well. You as well.
This is,
Mr.
this
Carl.
is Mr. Carly on the 1 o'clock on for arraignment.
Mr. Carly, good to see you. We spoke on the 3rd of this month. You promised me you'd appear, and I'm glad to see that you did. A little early, actually. Yeah, that's, yes. For the Joseph Daniel Carly is your full name. Mr. Carly, you were cited with a number of things: loitering, drug-related activity, controlled substance, knowing possession, burglary tools, possession of a dangerous weapon, loitering, knowing possession of a controlled substance. I'm going to appoint Mr. Haverco to represent you in these matters. He's going to enter a plea on your behalf at this time.
Thank you, Your Honor. Would stipulate the probable cause on all charges as the court to enter not guilty, please.
Mr. Carly, a plea of not guilty preserves your rights pending a pretrial. Now, what we'll want you to do is fill out that form with a mailing address on it. We're setting your pretrial for March 27th, and we'll have to mail you a copy of the of today's order based on insufficient staffing. Any question at all? Conditions of release, the most important one is no consumption of any non-prescribed substances. And of course, law-abiding behavior. Signed the order.
We've handed out
Carly,
the form.
if you bring us bring the form up here and leave us a copy of that, you'll be free to leave, and we'll see you back here on March 27th. Any questions at all? I want to thank you for appearing. You take care. Hey, Mr. Carly. Oh, you already, okay, good. Be well. Me again. And this is,
on the 11 o'clock, Curtis Lopez. And we placed a stipulated order of continuance into Oak Courts, what we call a slow reckless. For the matter to be continued for 24 months on the usual DUI-related conditions, at the end of which time, if he complies with the conditions listed, the charge to then be amended to reckless driving.
Mr. Lopez, Mr. Curtis A. Lopez. That's it. I'm looking at a stipulated order of continuance, which, as I've said many times, is a contract. It's an agreement between yourself and the city. I'm not a party to it. It's an agreement under the terms of which 24 months down the road, the charge can be amended to the much less serious charge of reckless driving. Still a serious charge, still a gross misdemeanor, but much better in terms of impact on your life than a DUI. The agreement requires that you pay a probation fee in the amount of $990.50. Stay out of trouble, law-abiding behavior, especially when it comes to alcohol-related offenses. And this is a really good idea. Obtain a drug and alcohol evaluation within 90 days and comply with any recommended treatment or conditions of it. Purpose of that, hey, there's a problem, let's find out what it is, deal with it so it doesn't happen again. Now, to get the benefit of this agreement, you need to abide by the conditions, and you've given up the right to go to trial, have witnesses, appeal if you lose. If there's a violation and the city proves that by a preponderance of the evidence, we'll have a hearing based on the police reports, and that would not go well in all likelihood. We don't want to go there. I want to be able to simply review the matter 2 years from now and close the case with a reduction to reckless driving. So Lopez, all I can do is wish you the best of luck. The charge is, it's serious because of all the damage that's done by people that drink and then get out on the road. All the people that hurt themselves and innocent bystanders, innocent other drivers. That's the number of people we kill every year is horrific on the road. I'm going to wish you the best of luck. Any questions? Leave your slip on the in that basket here on the podium. When we'll be mailing you a copy of the SOC, look it over real carefully, read it over carefully, and if you have any questions, give Mr. Everco a call. All I can do is wish you the best of luck. Stay well.
I'm going to meet with Ms. Wells.
Go into a recess at this time, or
Let me see. I'll refresh
you
myself.
prefer not to?
So this is Mr. Apodaca. You all need to speak with everybody at this point. So I'll meet
We're
with
going to be
Ms.
in
Wells.
recess at this time. We'll go back on record when, after you've had a chance to discuss your matter with Mr. Everco. 5, no trial, no appeal, simply a sentencing, which, this being a gross misdemeanor, could be up to 364 days in jail and or a $5,000 fine. And you have gone over the plea process with your attorney. I want to make sure of that. As to one count of driving a motor vehicle within the city of Yelm on December 27th, 2024, when the car was not equipped with an ignition interlock device as required by the Department of Licensing, how do you plead guilty or not guilty? Do you make that plea of your own free will? Anybody make any threats or promises to you to make you plead guilty? I will find the plea to be freely, knowingly, and voluntarily made, and your statement at 11 reflects that this is an Alfred plea. That means you've gone over the discovery with your attorney and want to take advantage of the plea bargain, recognizing that if the case were to go to trial, could be a bad result. I'll accept that. I do find that based on the file information that there is sufficient factual basis. City have anything further? No. Mr. Haverko, anything further?
Nothing further to add, Your Honor.
Ms. Henson, anything you'd like?
Actually, if I could be heard, as is typical, because it's not obvious that, Ms. Henson is indigent. I think the city did request the court impose costs, but I would ask the court to, waive any fines in this case, any court costs, because, she's currently not working. And what is your financial situation again? But she does receive food stamps and she has no income at this time. So I would ask the court to make a finding of indigency and not impose any financial costs.
Are you still under the ignition interlock requirement?
Yeah.
Do you have ignition interlock? See, do you have anything regarding the request? Ms. Henson, it sounds like you've already got enough on your plate to deal with without me adding a financial burden at all. I'm going to impose 364 days in jail. Suspend that all on the condition you have law-abiding behavior. That would include no drinking, most importantly, no drinking and driving, and not driving unless you're licensed and insured and equipped with ignition interlock, if that's required. Been kind of a rough haul here. All I can do is wish you the best of luck at this point and hope that things work out for the best. Hope that you find employment and lead a happier life. That I'm glad to hear. That I'm glad to hear. So don't give up on things. If you're doing well, keep doing well. Good luck to you. And we'll be sending you a copy of today's paperwork. Hopefully, you won't have any questions when you look at it. Good luck to you.
Yeah. Didn't, having to refill out some stuff, I'm just about done, but of course.
Well, that's safe.
It didn't, I thought I had something here saved. just about done.
No, that's,
Uh,
I want to thank
Ms.
you all for your
Wells,
patience.
come on up.
And this is,
This is Ms. Wells from the 10 o'clock calendar.
good morning, Ms. Wells.
We're placing a stipulated order of continuance into so we're placing a stipulated order of continuance and my browser just got stuck in Oak Courts again, so I don't know what happened. Hopefully it's saved. But it's a 2-year stipulated order of continuance, at the end of which time the charge of DUI would be amended to negligent driving a first degree. It's what we call a slow neg. City's just going to move to dismiss the suspended driving third degree count today. And the city's also going to move to dismiss the mitigation matter today. The conditions are the usual DUI related conditions, $990.50 court fee, and alcohol evaluation, comply with any recommended treatment, victim impact panel, and just, the usual conditions. Hopefully the form's in there. It's frozen in my.
The costs are $250 in the SOC.
No, it would be what it was on the DUI, $990.50.
We'll have to, do I have your permission to change that?
Yes.
We'll change that then. Morning, ma'am, for the record, your name is Tina Monique Wells. As well as, I'm looking at an SOC, stipulated order of continuance. Excuse me. It's a contract, an agreement between yourself and the city, under the terms of which this charge 24 months for 2 years from now will be reduced to the much less serious charge of negligent driving in the first degree if you comply with the agreement. The most important part to me is don't reoffend. And along with that, let's find out if there's a problem, and if there is, we can deal with it. Drug and alcohol evaluation and compliance with any recommended treatment, and get that started within the next 90 days to have proof with the court. The costs are $990.50, which you can pay over time, over the 2 years. And in return for that, you abide by the conditions, you get the benefit of what the city's given you. A much less serious charge goes on your record. If you violate the agreement and the city proves that, we'll have a hearing based on the police reports, and that would almost certainly result in a conviction for a much more serious charge. The good news is you're here, you're healthy, you haven't hurt anybody, you haven't hurt yourself. And that's why this the charge is as serious as it is. That's the good news, but please learn from the experience and do not repeat it. We'll need your address. That's been filled out. We'll be sending you a copy of the agreement. What I'll want you to do is, when you get it, look it over carefully. And if you have any questions about anything that's contained in the agreement, give Mr. Haverco a call, okay? Ms. Wells, good luck to you. You take care. That concludes the hearing. Drive carefully out there. I understand it's snow is on its way. If it's not here already, you take care of yourself.
Mr. Dees?
And for the record, docket number 7, improper lane usage and no insurance is dismissed, as is the second charge of driving a license, suspended or revoked, third degree.
This is John Dees. It's item number 5 on the 11 o'clock calendar. Matter comes on for the court pretrial hearing control substance charge. We placed a stipulated order of continuance into Old Courts. Matter to be continued for 12 months on the condition of no new criminal law violations, at the end of which time the city would then move to dismiss. Dismiss after 12 months.
Morning, sir. Full name, John Albert Dees. Mr. Dees, disagree with anything Mr. Haverco just said? What you have here, negotiated by him on your behalf as a a contract with the city. If you do your end, follow the conditions, the charge will be dismissed. If you violate the agreement and the city proves that, we'll have a hearing based on the police reports alone, and that would almost certainly result in the conviction and the possibility of up to, say, 180 days in jail. Don't want to go there. You know, save your life. I've hearing too much about people that aren't making it, hence the necessity for all officers to carry naloxone with them in case of overdoses, and they're dealing with that, it seems, more and more. Mr. Dees, I'm going to wish you the best of luck. You take care of yourself. Hopefully, we can review the matter 12 months from now and find you in compliance and dismiss the citation. Any questions at all? No. Mr. Dees, good luck to you. You take care.
Albert?
Morning, sir. Is it Spencer Ellsworth, Albert? Good morning, sir.
So we've got to do. Give me 1 second.
We don't want, there's enough tiredness in the court. We don't want exhaustion. Well, it's a cold morning.
So we have to do a couple of orders this morning. We have to do a pretrial order, would set some dates, and we have to do a bench trial. So we're just kind of doing that right now. Let's see. So I placed a pretrial order into our courts. The city may want to take a look at it because there's a section if the city wants to use any statements by the defendant. We're setting it for trial here, and then I'm going to add I got to find it. The jury trial. Waiver.
Setting the matter for, I'm looking at the pretrial order.
Oh, here we go. I was looking for the waiver of jury trial. One second.
Scheduling, what are we looking at?
We were wanting to put a new, when Sonia's done editing, I was gonna, or if you could just put a commencement date, a couple months out, please. That's under section 6. No, for where it says commencement date, click it out 2 months. Yeah. Yep. Yep. Right. That's the city, or do you have any? Are you pretty open? You're good. It's always gonna be on Thursday. So just wherever it's convenient to put it.
We need a readiness hearing, and at that hearing, we could set a trial date, is that what?
No, let's go ahead and just set a trial
Set a
date.
trial date?
Yeah, set a trial date and set a readiness date. Yeah. So just go out 6, 8 weeks. Sure, yeah. Then pick the readiness date 2 weeks prior.
April 10th trial, 24th?
Sure.
What you're looking at?
Yeah. That works. Did you fill out the address thing? Okay. Did you hand that up?
Line above trial.
Oh, there you go. Right, weren't we doing trial April 24? Yeah, April 24 and then readiness.
10th and 24th.
It'd be April 10th.
10th and 24th.
Yeah.
Mr. Albert, you have two court dates, one April 10th, readiness for trial on April 24th. Then trial, there's last minute motions. Make sure everybody has what they need and make sure everybody's ready to go. It's sometimes quite an operation getting ready to and then proceeding to trial. Any questions at all? $10 on the first hearing, and the April 24th, we'll have to figure out what at noon. In the meantime, keep in touch with Mr. Haverco if your contact information changes. Let him know.
Okay.
Albert, thank you.
Next matter is going to be that of Jennifer Berger.
Good morning.
Matter comes on for a pretrial hearing for a theft charge to which she's going to enter a straight plea to the charge.
Morning, ma'am. Is your full name Jennifer Lynn Berger?
Yes.
Berger, I'm now looking at in courts a statement of defendant on plea of guilty to 1 count of theft in the 3rd degree. Plea form tells me you're 56 years of age. Any problem at all going over the plea process and the form with Mr. Haverco? Now, if you accept the plea, if I accept the plea, you give up the rights contained in paragraph 5, no trial, no witnesses, no appeal if you lose, simply a sentencing, which could be up to 364 days in jail, given that this is a gross misdemeanor. You realize that. That of mine is to one count of theft in the 3rd degree alleged to have occurred within the city of Yelm on November 29th, 2024. How do you plead guilty or not guilty? Do you make that plea of your own free will? Anybody make any threats or promises to you to make you plead guilty? I'll find the plea to be freely, knowingly, and voluntarily made. And your statement in paragraph 11 does satisfy the factual elements of the plea. For the recommendation is to
Well,
sentence.
we'd like to be heard as to that.
Yes.
The city, you know, in an ordinary course is recommending all suspended jail time 364 with all 364 suspended, which is a reasonable recommendation, and a $250 you know, court fee. You know, she has a prior a theft in 2001, quite a long time ago. And then she has a prior, what was called shoplifting, a theft, but a shoplifting from, I think, Tacoma Municipal Court in 1996. So last time she had a violation of this type is 2001. So it's 20, you know, 20.
Been a while.
Been a while. And, you know, she works part-time for UPS. And, you know, we talked about, like, usually when someone presents with a plea to a theft, and that's kind of what they do, they usually have other violations that are more recent in time. You don't see every day when someone had a charge so long ago and then violates again. And she indicated she's not even really necessarily sure why she did this, but we had set it over from last time because she was worried about what this charge was going to do to potentially her employment. And of course, I told her, of course, you know, judge may ask you that, and you know, you'd have to have a reason for that. So I told her that what I'd argue for her, notwithstanding the fact that the court's aware of these two priors from a long time ago, I told her that I would argue for a deferred sentence. I explained to her that the court does have discretion to defer a sentence on conditions, after which, if the court were to do that for 12 months, then the charge could be dismissed. I'm not sure what the city's position is on that issue, but she seems to feel remorseful, and you know, I'm even puzzled as to why it happened, but you know, so that's essentially the ask. Like I say, the city's recommendation is reasonable, but she
So do you have any response? Ms. Berger, anything you'd like to tell me? Well, we all do things we wish you could undo, but hey, unfortunately, time passes, we can't. It is, you know, troubling that the amount of time between offending and usually, you know, that's sometimes people shoplift or commit this offense when there's you know, depressed or feeling down about things or not well. I'm hoping everything is going okay in your life. I will defer the sentence for a period of a year. If during the year you pay a monitoring fee of $250 at $25 a month, stay out of trouble. Recommit. The charge will be dismissed at the end of the year. That's well. Thank me by being good to yourself. You know, we make mistakes. Forgive yourself. You know, and learn from mistakes. And maybe try and think about, you know, why you would do something that's you haven't done for many years. Maybe think about that. I'm going to wish you the best of luck signing the order here in a bit, and let
me take a look. Yeah, yeah. if I can get Oakworks to close my document here. It's like, jeez. So. Let's see. Yes. Wait. Let's see. Oh,
That's it. Just with the,
it's, there's a drop down. Let me see. But where, the part where it says 364 days in jail and then 364 suspended, there might be a drop down there. I won't let me get into it, but there might be a drop down that says deferred. Oh, okay.
It's right.
I think we're good to go. Now citing the judgment and sentence. Ms. Berger, I wish you the best of luck. You take care of yourself and be well and above all, be good to yourself. And maybe spend some time considering, why, what prompted you to do that. And you may never get an answer. But sometimes the thinking about it will bring you some peace.
Thank you.
Ms. Berger, thank you. You take care of yourself.
You're welcome.
For 1 o'clock? What's the name? But one key that he can't appear or she can't appear.
She asked if they could both appear.
Are we doing, are we now doing the no-shows? So on the 10 o'clock, there's a John Stahl that was on for pre-trial. I haven't had any contact with him.
Stahl or Staley, I forget how that's pronounced.
It's an old, kind of an old case, right? It's from 2021.
Yeah, the case has just a little bit of age on it.
Yeah.
That's Staley, number 5, page 7. one of your perennial non-appearances. So ordered, 1,000 cash or bond, failure to appear. And Marcus Williams.
He called in and I was handed a note, I believe, this morning from, Donnie. And, he had called claiming he was in the emergency room. Apparently it was really noisy in the background, a lot of moving around.
Sounds like an ER.
So I,
I'll find them.
okay.
He has been in contact, so note the non-appearance for speedy trial purposes. Reset with notice.
And then Jose Emilio Hernandez, this is a fellow who, just for the court and the city's, knowledge here, trying to figure out what to do with this guy. He, has indicated to me when he's been here, there may be some kind of a competency issue. He's often disoriented. I know one of the pre-hearings he was at, he was asleep. He couldn't seem to really wake up. So I've been trying to.
He's the one that was.
Yeah, I spoke with one of the, felony, public defenders over in the county, who I luckily just happened to have spoken with her before, and that's how I got through, because they never return my inquiries ever. But
Yeah.
apparently, I mean, like, I can't seem to get any information, but there's at least a suggestion that in his felony case in the county, there may be some competency issue going on. So I don't know if there's been an evaluation of any kind or what's happening. I haven't been able to get that stuff, but.
And any contact with the guy at all, or?
No, as to his lack of appearance today, I haven't, and I never am able to have, as I recall, he doesn't have a phone number, and at best, he has an email that he doesn't respond to, so I haven't had any contact since the last time I saw him in court. I don't have any other information.
What do you want to do?
City.
Case management decision.
Yeah.
That leaves us with just one, Diane Thomas.
Yeah, and, my notes, let me just.
DUI, New Year, Christmas Eve.
So basically on the 10th, she had given me a number. It wouldn't accept a message. There was no voicemail set up of any kind. I texted to the number. When you call the number, it says they're not available, but they don't give you any options. So I sent a text. There's no voicemail option. I haven't received any return contact.
Well. DUI, and I think that answer you got usually indicates that they just blocked all calls, I think.
Oh,
So ordered. Asher. That is it for the, Didek, yeah. Going to the 9 o'clock, page 5, docket number 11. This is a 22 case. Josh Sneevil was the lawyer set for a pretrial in the state. Yeah, that's. She was arrested on the warrant. I spoke to her. She assured me she'd be here February 13th, 9 o'clock.
You haven't had any.
It was Josh.
Yeah.
right. fine. Then the one that we, oh, yeah, oh, yeah, yeah. Well, no, weren't you dismissing, yeah, no, you were dismissing you were dismissing Hernandez. I think he was in the middle of surgery.
Allegedly.
Yeah.
Yeah, it's snowing sideways out there. Well,
Really?
they said. Interesting day. Order dismissal for Jose Hernandez as we speak. And with that, we can go off record. Before I call the calendar, is anybody here with a private counsel? Yes, sir. Your attorney's appearing by way of Zoom. Okay. We don't have her present at the time, but as soon as she does show up on Zoom, we'll call your matter. If I remember correctly, you're Mr. Mawicki? Mr. Mawicki, if I mispronounce your name, I apologize. Good afternoon. I hope everyone that's been here has filled out one of these forms. We're very shorthanded today, and we're going to have to mail you a copy of today's order, which will have your next court date on it, as well as contact with Mr. Haverco. His information will be there as well. You're here for an arraignment, which is your first appearance after receiving a criminal citation. I need to let you know you have a right to have a lawyer represent you at all stages of any criminal proceeding, including this one here. At this appearance, you read the charge that's against you and the possible penalty, and a plea will be entered on your behalf, and that plea is invariably not guilty at this stage of the case. We next set the matter for a pretrial conference. That's a chance for you to discuss the case with your attorney, and he in turn with the representative of the city, which is seated here to my right, Mr. Ratfield. If you're going to reach an agreement regarding the disposition of a case, that agreement is put on the record. And if you can't, you have a right to a public and speedy jury trial in the county where the offense was alleged to have been committed. Have any question about anything I've just said, ask me or Mr. Haverco when you approach the bench. John Appleby in the courtroom. John Appleby. Mr. Appleby, you promised me you'd appear. Thank you for appearing. Full name, John Robert Appleby. Citation alleges that on February 7th, 2025, you committed the offense of disorderly conduct. Mr. Appleby, that's a simple misdemeanor. The maximum penalty on conviction would be 90 days in jail and or a $1,000 fine. I'm going to appoint Mr. Haverco to represent you. He'll enter a plea on your behalf at this time.
Stipulate the probable cause as the court to enter not guilty plea.
Mr. Appleby has indicated plea of not guilty preserves your rights. Conditions of release are law-abiding behavior and no consumption of alcohol and or non-prescribed drugs. Mr. Appleby, we're setting a pretrial for April 10th. You'll receive the order by mail. Stay in touch with Mr. Haverco in the meantime. Any questions of myself? I'm going to wish you the best of luck. Mr. Appleby, thank you for appearing. Thank you, sir. Royce Bedeau. Good afternoon, Sue. Is your full name Royce Anthony Bedeau?
That's correct.
Mr. Bedeau, the citation alleges that on or about February 3rd, 2025, you committed the offense of driving while under the influence of intoxicants. That is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'll appoint Mr. Haverco to represent you, and he'll enter a plea on your behalf at this time.
Stipulate the probable cause, Your Honor, ask the court to enter not guilty plea.
Mr. Bedeau, a plea of not guilty does preserve your rights. The conditions that we went over while you were in custody, those remain in effect. Don't drive unless you're licensed and insured. Don't drink and drive at all. Stay in touch with Mr. Haverco. And
write your phone number in here. Sign here. It's electronic. What is it? Oh. He wants to, he'd like to address the court on the issue of some property that was taken into custody pursuant to his arrest.
That would be either in the custody of the jail or in the police department. Talk to the police department about that. I have no idea whether they want something as evidence.
It just took me a few, I went there to check out.
Well, now you've appeared, unless the city needs it as evidence of some kind. I can't imagine why, but yeah, that should. There's an officer right outside the room. Ask him what you're going to need to do. Okay. Good luck. Take care. Rachel Blake in the courtroom. Rachel Blake. Good afternoon, ma'am. Is your full name Rachel, middle initial S, Blake? The citation alleges that on or about January 30th, 2025, you committed the offense of theft in the third degree. That charge is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'm going to appoint Mr. Averco to represent you in this matter. He'll enter a plea on your behalf at this time.
Stipulated probable cause, Your Honor, ask the court to enter not guilty plea. Phone number.
Like that concludes the matter. If you've given Mr. Averco your contact information, we'll be mailing you a copy of today's order. It'll have the court date on it. That's March 27th. Any questions at all? Thank you for appearing and good luck. Russell Chenier. Russell Chenier does not answer. A number of people will not answer. After I've talked to each and every one of you, I'll go back over the files. If there was probable cause to issue the citation, a warrant will be issued for the arrest of the non-appearing person. So I want to thank you all for coming, and you've at least saved yourself a warrant by just showing up. How about Jeremy Crahan? No luck there either. Jeremy Crahan does not answer. Kirsten Crary. Good afternoon, ma'am. Is your full name Kristen, middle initial A, Crary? Ms. Crary, the citation alleges that on or about February 7th, 2025, you committed the offense of theft in the third degree. Again, that's a gross misdemeanor with a maximum penalty of 364 days in jail and or a $5,000 fine. Once again, I'm going to appoint Mr. Averco to represent you in this matter. He'll enter a plea on your behalf.
Stipulated probable cause, Your Honor, ask the court to enter not guilty plea.
Plea of not guilty does preserve your rights. You've given your contact information to Mr. Averco.
I'm assuming that's a nine.
Thank you, ma'am. We will be mailing you a copy of today's order. Pre-trials, March 27th. Take care and thank you. Marcus Phobes, F-O-B-E-S. Good afternoon, sir. Full name, Marcus Allen Phobes. Mr. Phobes, citation alleges that on or about February 8th, 2025, you committed the offenses of theft in the third degree and criminal trespass in the first degree. Each of those is a gross misdemeanor with a maximum penalty of 364 days in jail and or a $5,000 fine. So again, I'll appoint Mr. Haverco to represent you and enter a plea on your behalf at this time.
Stipulate to probable cause, ask the court to enter not guilty plea.
Mr. Phobes, a plea of not guilty does preserve your rights.
Yep, phone number.
Pre-trial will be March 27th. Give Mr. Haverco your contact information if you will. Stay in touch with him.
564-22. 626. And then you need to sign. Where you go? Silence. Okay.
Well, thank you very much. Is Charles Jarrett in the courtroom? Charles Jarrett. Hearing no response. Jennifer Jones. Good afternoon, ma'am. Is your full name Jennifer Renee Jones? Ms. Jones, now other people in the courtroom are going to have the same situation. As you walked in here, you were cited with the criminal offense of driving a license suspended or revoked in the third degree. That's what they call a misdemeanor. A maximum penalty on conviction to be 90 days in jail and or a $1,000 fine. The city ordinarily has a motion and they nodded in my general direction. They've reduced the charge, amended it to the civil infraction of no valid operator's license on your person. The difference is this. With a criminal offense, if you're convicted, you go to jail. With a civil infraction, it's a fine. No more, no less. You don't plead guilty to a civil infraction, you admit it or deny it. If you admit that you didn't have a valid license when you were cited on February 6th, I'll assess a $150 fine. If you deny that you committed the infraction, you're entitled to a contested hearing. It being a civil infraction, you're not entitled to a jury trial, but you are entitled to a hearing where the city would have to prove that you didn't have a valid license. Now, do you have any questions about anything I just said? Do you admit or deny that you didn't have a valid license on your person when you were cited on February 6th? I'll assess a $150 fine. The question I have of you is, do you know what you need to do to reinstate your license? Money is what it. Oh, okay. Now, all I care about is I want people to get licensed, okay? That's we live in a world where it's kind of hard to get around at all without being able to drive from here to there. So I want you to make that I'm going to advise you to make that a priority in life. Get yourself relicensed as quick as you can. Ms. Jones, good luck to you and take care. We'll be mailing you a copy of the order on today's prints. You can pay that at $25 a month and good luck in getting reinstated. Take care. Lawrence Keel, K-E-E-L-E. Does not respond. Tabitha Lynn Coop. Tabitha Coop, K-O-O-P. Victor Messias Perez. Mr. Messias Perez, good afternoon. And for the record, I have to affirm that your full name is Victor Manuel Messias Perez. Citation alleges that on or about February 9th, 2025, you committed the offenses of driving a license suspended, revoked in the third degree, simple misdemeanor, maximum would be 90 and or 1,000 on the conviction. You're also cited for operating a motor vehicle without ignition interlock when required to have that by the Department of Licensing. That charge is a gross misdemeanor. Maximum penalty there would be 364 days in jail and or a $5,000 fine upon conviction. What I will do is appoint Mr. Haverco to represent you in this matter, and he's going to enter a plea on your behalf.
Stipulated probable cause, ask the court to enter not guilty, please.
Mr. Messias Perez, as I indicated, preserves your rights,
Write your number.
set a pretrial in your matter.
Write your phone number in here. Mhm.
Messias Perez, we apparently not, we want to make sure we have your correct address. We have it now. Yes.
Hey, wait.
Now, this is a matter you're going to have to discuss with Mr. Haverco, your attorney. That's unfortunately, that's one of the consequences, very unfortunate consequences is this ignition interlock requirement, which costs money. But what your problem is, I'm very well aware of. That's a problem many people have. That's something you're going to need to talk to Mr. Haverco about. Pretrial will be on March 27th, and once again, we'll be mailing you a copy of today's order. Mr. Messias Perez, I'm going to wish you the best of luck. You take care of yourself. And again, talk to Mr. Haverco when you have a chance about that.
Yeah, free to go.
Mike Mattingly? Mike Mattingly. Good afternoon, sir. Full name, Mike, middle initial R, Mattingly. The citation alleges that on or about January 28th, 2025, excuse me, you committed the offense of driving a license suspended or revoked in the third degree. Once again, that's a criminal offense. This is Mr. Mattingly. DWS third. It's now a civil infraction, no longer a criminal offense. If you admit the infraction, I don't know if you were paying attention to what I said earlier. If not, DWS third is a criminal offense. If you were convicted, there's a possibility you could get up to 90 days in jail. The city has amended the charge to a civil infraction. No jail time is possible. If you admit it, that you didn't have a valid license on your person when you were cited on January 28th, I'll assess a $150 fine. That ends it. You're also entitled to a contested hearing if you deny that you did anything wrong. Okay? Do you know what you need to do to get your license back?
Yeah, it's pretty struggle, but I
It's money, and here we are adding to the grief a little. I would make that a project in life. That's the best I can advise you to do is do what you can. Yep. Unless you take that first step, you're never going to get there. So do that. Mr. Mattingly, good luck to you. You take care, and hopefully you'll be relicensed before too long. No, we'll be mailing you a copy of today's ordinance. Andrew McLeod. Andrew McLeod in the courtroom. Still up there? Huh. Mr. Winnicki, we would call you next, except your attorney has not appeared yet. We're waiting for her, and we're keeping an eye on the screen here. The minute she checks in, we'll call your case. Megan Norgard. Good afternoon, ma'am. Full name Megan Kelly Norgard. Citation alleges in honor about February 8th, 2025. You committed the offenses of theft in the 3rd degree and criminal trespass 1st degree. Each of those is a gross misdemeanor with a maximum penalty of 364 days in jail and or a $5,000 fine. Ms. Norgard, I'll appoint Mr. Haverco to represent you in this matter. He'll enter pleas on your behalf.
Stipulate to probable cause, Your Honor, ask the court to enter not guilty, please.
March 27th will be your pretrial, 10 o'clock in the morning, and that'll be in the order that we'll mail to you. Stay in touch with Mr. Haverco, and again, his name and contact information will be on today's order. Norgard, thank you for appearing. That concludes the matter. Good luck. Christopher Oberst. Christopher Oberst in the courtroom? Does not respond. How about Melissa Olson? Good afternoon, ma'am. Full name Melissa, middle initial E, Olson. Citation alleges in honor about January 22nd, 2025. You committed the violation of violating the terms and conditions of a protection order. That charge is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I will appoint Mr. Haverco to represent you in this matter, and he'll enter a plea on your behalf.
Stipulate to probable cause, Your Honor, ask the court to enter not guilty, please.
Plea of not guilty preserves your rights. Now, conditions of release are law-abiding behavior, of course, and that especially includes abiding by any and all existing no contact orders or protection orders until they're modified by the issuing court. Any questions?
Yeah.
Olson, thank you very much. Thank you, ma'am. Take care. Shanta Ouk is the, not knowing how to pronounce that name, I thought I'd better ask. How do you pronounce your last name? Full name, Shanta, no middle initial, Oak. Citation I have alleges that on or about January 31st, you committed the criminal offense of driving a license suspended or revoked. City may have a motion in that case, and that is now a civil infraction. If you were paying attention, the difference is civil infraction. If you admit it, I fine you. Criminal offense, you can go to jail, not on an infraction. You also have, you were cited for not having any insurance that you failed to display. Any question about anything I've just said? Do you admit or deny the infractions? If you want to talk to Mr. Haverco about what's going on here,
You know what's going on? He just wanted the city to know that, he is licensed.
That's great. How about insurance? Did you have insurance on you? Do you have it now? Not yet. Well, let's,
So what they're proposing to do is to amend the criminal charge to no valid operator's license because he reaches an infraction. That would be a penalty. You were suspended. But they're going to amend it to civil. You just need to-
yeah, I'm
He
very
had-
glad
he
you
had-
have your
he had-
license now,
yeah.
but the question is did you have it on January 31st? That's it.
Yeah, he indicated to me, he admits.
It'll be 150 on the suspend or no valid license charge. However, the insurance, that's for $559 ticket. That's way too much. Let's reduce that to 100 even. And you could pay this at the rate of $25 a month. You have reinstated your license. It's pretty easy to lose and it's a lot harder to get it back. So now that you have it back, please, Mr. Oak, make sure you keep it, okay? Any question at all? We'll be mailing you a copy of today's order and good luck to you. And again, congratulations on getting your license reinstated. Take care. Michael Pace, P-A-C-E. Good afternoon, sir. Is your full name Michael Antonio Pace? Mr. Pace, the citation alleges in honor about January 30th, 2025. You committed the offense of hit and run attended vehicle. That charge is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I will appoint Mr. Haverko to enter a plea on your behalf.
Stipulated probable cause, Your Honor, as per ten or not guilty plea. Right, your phone.
Today's conditions of release are law-abiding behavior. Pretrial is set for March 27th. Please, good luck. That concludes the hearing. Free to leave and we again sign here. Earl Palmer on the court. Good afternoon, sir. That's a little repetitious here, but you also were cited, cited on February 5th with a driving license suspended, revoked, third degree. Also cited for not having insurance. The city is amending the one criminal charge to the civil infraction of no valid operator's license, second degree. And as if you're paying attention, you can either admit the infractions, deny the infractions. If you admit, I'll impose a fine. If you deny, we can set it for a contested hearing. First, any questions about anything I've just said? Did you have insurance by any chance? Have you gotten it? Where are we on that? 150 on the NVOL, and that 559 is way too much, as I indicated earlier. Let's reduce that to 100 even, okay? It's reinstating your license is sometimes a pretty expensive procedure, but I'll want you to do that if you can. That'd be great. Signing the order. And we'll, of course, be mailing you a copy of that. Mr. Palmer, good luck to you and take care. Isaac Pollard. Does not answer. Bo Radici. Does not answer. John Ransom. Good afternoon, sir. That's full name Jonathan William Ransom. Mr. Ransom, you likewise, like others before you, were cited with driving license suspended, revoked, third degree, and the city may well have a motion and does reduce the charge to the infraction of NVOL second degree. If you can, if you want to admit that, I'll impose a $150 fine. You can also deny it, and we can set it for a contested hearing. And do you have any questions about it? 150 it is, Mr. Ransom, and do you know what you need to do to? Oh, perfect. That's you know, I maybe should have said this earlier, but a lot of people don't realize that their license has been suspended because they mail the notice of suspension to your last known address. And the way we move around from here to there, we may change the address with we have with the post office, but rarely do we think to change it with the Department of Licensing. But Mr. Ransom, I'm really glad to hear that you're reinstated, and of course, I'm hoping now that you have your license reinstated that you keep it. Good luck to you, and thank you. We'll send you a copy. It's very short. Gilberto Rivero does not answer. How about Joey Rogutt? I'm probably mispronouncing that. Rougutt. Paul Harvey Scott, I do not see. Jordan Skiles. Good afternoon, sir. Things are getting a little repetitious. Mr. Skiles, you also were cited with driving a license suspended or revoked in the third degree, and city may have a motion on your case as well. Mr. Skiles does, your citation is now no valid operator's license in the second degree. You probably heard this a number of times. Any questions about the process? You can either admit the infraction, deny it. 150 it is, and then you know what you need to do to reinstate your license. Sometimes there's quite a hill to climb there in terms of unpaid fine. Who knows? It could be a number of things, but unless you get started, never going to get there. So I advise you to get your license. Start working on it anyway. Good. You've started. That's important. Good luck to you. Take care and have a good day. Drive carefully out there. It looks like it's gotten a little slippery maybe. Tyson Snyder. Tyson James Snyder. Snyder, the criminal citation is driving a license suspended or revoked third degree. City probably has they're amending that to the civil infraction of no valid license on your person. You're also cited for no insurance and speeding. So you got 3 infractions. You can admit 1, 2, or all 3 of them, or you can deny 1, 2, and 3. You did have insurance. Some courts ask proof of that. I'm gonna take your word for that and I'll dismiss that, citation with, I have to assess a $25 cost, with a little better than 559. And this meeting, let's make that 100 even, and the, DWS third down to Noval 2, that's 150. That works out to 275, which is a little better than where you started. But Mr. Snyder, I'm gonna wish you, the best of luck. I'll sign, it takes me a minute to get back to the, dashboard. Oh, so we're working. Mr. Snyder, again, we'll be mailing you a copy of today's order. If you have any question about anything that's on it, give us a call. Hey, take care of yourself. I finally just got to it. Is there any question? You got a new ticket? Jack? Yes. Just wait till you get today's paperwork. Let me hold on just a sec. We set you up 25, your first payment would be due March 13th. So, and they're all combined into one. The order will reflect all three. That's it. Okay, thank you. Good luck. Take care. Cody Stevenson. Come back to that matter. Aaron Strong. Not getting an answer. How about Sandra Trepanier? Probably mispronouncing that. Howard Ullman. Good afternoon, sir. Is your full name Howard Dion Ullman? Mr. Ullman, you also were cited with a lot of that going around, I guess, driving a license suspended or revoked third degree. I think the city is, and they are amending that to no valid operator's license in the second degree, the civil infraction. If you admit the infraction, it's a $150 fine. If you deny it, we can set it for a contested hearing. Now you look like you might have a question. Okay. Oh, I have a question. Do you know what you need to do to reinstate your license? That's good news. That I'm glad to hear. Little easier to lose it than it is to get it. That's it. Mr. Ullman, I'm signing the order. That concludes the hearing. We'll be sending you a copy of the order. Mr. Ullman, good luck to you. Thank you for appearing and thank you for reinstating your license. Take care of yourself. Melissa Ulrich. Good afternoon, ma'am. Again, for the record, full name Melissa, middle initial J, Ulrich. Citation alleges that on or about January 30th, 2025, you committed the offense of assault in the fourth degree. That's a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I will appoint Mr. Everco to represent you. He will enter a plea on your behalf at this time.
Stipulated probable cause, aspartame or not guilty plea.
Ms. Ulrich, a plea of not guilty does preserve your rights pending a pretrial, which we're going to set it for February 27th. You already have a hearing set for that day. So we can address both the matters at that time.
Right in front of you down here.
Rick, I'm signing the order, setting the matter for hearing on February 27th. That concludes today's hearing. Good luck to you. We'll see you at the end of the month.
Yeah, but before
Thank
go,
you and take care.
Just wait one second.
Yeah, make sure Mr. Everco has your,
Yeah, I do. I'm just waiting for that opportunity for her to sign. the order.
okay, great.
Sure. Free to go. Yeah.
So Rick, thank you. Take care. Destiny Wilson. Good afternoon, ma'am. Full name Destiny Renee Wilson. Ms. Wilson, the citation I have alleges in honor about February 9, 2025. You committed the offenses of driving while under the influence of intoxicants and a second charge of reckless endangerment. Each of those is what they call a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'm going to appoint Mr. Everco to enter a plea on your behalf, and he'll represent you throughout the course of the case if you're indigent.
Stipulate probable cause, Your Honor, ask the court to enter not guilty pleas. There's a couple of cases. Yes.
Yes. Ms. Wilson, the pretrial set for March 27th at 11 o'clock. That'll be in the order that we send you, and that order will also have the contact information with Mr. Everco. The conditions released earlier set remain in effect. That don't drive unless you're licensed and insured. Don't drink and drive. If any officer asks you to take a breathalyzer, you're to do so.
I need a phone
Any
number.
questions? I think the officer who's standing outside the courtroom has it. I think needs you to sign off and we'll give
I
it
need
back
your
to you.
signature on this pad. And then do you have a phone number? Yes.
Ryan Young in the courtroom? I do not hear.
528. All right. Yeah, so you're done here. Go talk to the police department. See if you can get
No. Oh, ma'am, just talk to the officer. I think he's got your phone with him. That's just come back in and let me know if there's a problem, okay? Wiki, Ms. Bowden is now on. Excuse me.
Hello, Your Honor.
Good afternoon.
Good afternoon. My name's Lucas Combs. I am phoning in on behalf of Mwaniki and for attorney of record Barbara Bowden.
Hey, good afternoon, and thank you. I see, I can see the number you're calling from, but I don't have a picture.
No, we were unable to connect via Zoom, so we just used the telephone line. If that's acceptable.
It is. It is. Your client is in the courtroom. I'll have him identify himself for the record. Sir, is your full name Eric Maroki Waniki? If I mispronounce your name, I apologize. Citation alleges that on or about February 10th, 2025, you committed the offense of driving under the influence of intoxicants. That charge is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. At this point, I'm going to turn to your counsel, your attorney, to enter a plea on your behalf.
Thank you, Your Honor. I did get a chance to speak to Mr. Mwaniki, and we went over his rights at arraignment. We went over the charge, the maximum penalty for the charge. We stipulate to probable cause for the purposes of this hearing only. We waive formal reading of the complaint and enter a plea of not guilty.
Plea of not guilty preserves your rights. We'll set the matter for a pretrial. Next available dates would be March 13th or the 27th at 9 a.m.
That works, Your Honor, if it works with Mr. Waniki.
Mr. Winnicky, what were, do either of those dates work for you? Yes.
March 13th, Your Honor?
That's, your client would prefer the 27th, I think.
27th? Okay. Thank you.
27th it is. Any conditions
Thank you, Your Honor.
set, when we spoke on the phone, those remain in effect. Don't drive unless licensed and insured. No drinking and driving at all. There's no priors. I'm not asking for any further conditions. Stay in touch with your attorney and be back here in court on the 27th of March. Any questions at all? Mr. Winnicky?
No, Your Honor.
Mailing you a copy of today's order, and we'll send your attorney a copy of the order as well. Counsel, anything further in this matter?
No, Your Honor. Thank you.
That concludes the hearing. Take care and talk to you again on the 27th, more likely than not.
Okay. Thank you, Your Honor.
That takes care of the matter. And again, we'll be mailing you a copy of today's order. Sorry for the delay, but such things happen. You take care. Thank you, sir.
Mr.
Yes,
I think
has shown
that's-
up. I think we dismissed
that's
that.
the case we might have dismissed earlier.
I'm quite sure that it is.
Yeah, I think this is Jose Emilio Hernandez.
And he's asleep, I think.
Yeah.
Mr. Hernandez, are you? Come on up. Emilio, I'm sorry.
I think the city had already made a motion earlier.
Yes, and I believe
Yeah, I think so.
as soon as if I can get back to the dashboard, I'll verify. I recall signing an order of dismissal in this matter. Yes. Mr. Hernandez, a order of dismissal has been signed. How are you? Anyway, this closes the case. You don't have to worry about coming back to court. Okay. The city reviewed the matter and decided to dismiss the charge. Okay. Charges, you should say. 3 charges. Good luck to you. Thank you and take care. And with that, we can go off record. Oh, well, yeah, let's go on. Back on record for the 1 o'clock no-shows. Starting on page 11, go to docket number 5, Russell Chenier. Docket number 5, DDLS third, amend to no vol 2 and FTA. Docket number 6, I find probable cause for the issuance to him of a citation for controlled substance, knowing possession. Probable cause was previously found when he's been released from jail, 1,000 cash or bond. Next would be Jeremy Crehan, docket number 7, and docket number 8. He was released from jail at time by myself when probable cause was found for each theft charge of 1,000 cash or bond on each. Next one would be Charles Jarrett, docket number 11. Find probable cause for the issuance to him of a theft citation. He did not appear. 1,000 cash or bond, warrant issue. Docket number 13, Lawrence Keel, amend DDLS third 2, no vol 2, and FTA that. And with 14, same defendant, Lawrence Keel, simply FTA the no insurance ticket. Tabitha Coop, docket number 15, find probable cause for the issuance to her of a theft third citation, 1,000 cash or bond. Warrant will issue. Andrew McLeod, probable cause has been previously found when he was released from jail on his promise to appear. Warrant will issue 1,000 cash or bond. Next would be Christopher Oberst, page 14, docket number 21. Amend DDLS third 2, no vol 2, and FTA it. Everybody else on the page did appear, however. Next page 15, docket number 28. Amend Mr. Pollard's DDLS third citation to no vol 2 and FTA it. Docket numbers 29 and 30. I find probable cause for the issuance of all the charges on him previously found. He's been released on his promise to appear before. However, now he's out on bail, and go ahead and prepare the forfeiture notices to the bonding company on both cases. I think you'd bother to post bail, you'd show up. Next would be Alberto Rivero. Probable cause was previously found on him. He was released from jail after being booked in. Oh, I'm sorry. Yeah, 1,000 cash or bond and forfeit. Reissue 1 each. Alberto Rivero. He's been booked in before. Find probable cause at that time when I released him from jail on his promise to appear. Docket number 32, 1,000 cash or bond. Docket number 33, same 1,000 cash or bond. Docket number 34, Joey Roget, find probable cause for the issuance to him of DWS third and operating a vehicle without ignition interlock, 1,000 cash or bond. Paul Harvey Scott speaks for himself. He was released from jail when I found probable cause for disorderly conduct, 1,000 cash or bond. Cody Stevenson, go ahead and reset that with notice pursuant to the docket note. The next one, Aaron Strong, probable cause was found for NVOL without hit and run when he was released from jail on his promise to appear, 1,000 cash or bond. Aaron Strong's docket number 41, simply FTA the 2 infractions. On Sandra Trepanier, docket number 42, find probable cause for the issuance to her substance, knowing possession of a controlled substance, citation, 1,000 cash or bond. That brings us to the last one, Ryan Young, find probable cause for, DDoS 2, 1,000 cash or bond. And with that, we can go off record until, until Well, the 2:30 calendar, it is now 2:42. Donald Clark was scheduled for a contested hearing on 3 different infractions. He has not appeared. And maybe he's running late because of the weather. I suspect not, but if he does not appear, I'm gonna say by the end of the day tomorrow, give him tomorrow, just FTA the 3 infractions that he was cited with. I'm not sure what that means, has not the effects. The Gulf of America.